incorporate the word which is before the beginning of consolidation under section A, subsection 2, and section B, subsection A. Obviously, we'll reflect on that one. Chair, I've spoken about the fact that the definition regulatory authority raised by Gauteng Management Agency, they requested that we delete the phrase because it does not include a regulatory entity in terms of this act. The words are very important to clarify the regulated entities, which are not regulatory authorities. Also, it is not clear why these words should be removed from the commenter there. So let me be clarified with the respective comment. This was raised. Economic regulation here, they indicate, Translate indicated that the definition of economic regulation undermines the limit of the scope of the NBSH Act. Therefore, Transnet recommends the definition of economic regulation should be reviewed and include all activities or sectors that they will seek to regulate. We said we agreed that proposal and it will be incorporated in the bill, obviously, after we've been given direction by the committee here. I think it's more about providing clarity on the distinct functions of the regulator and the Competition Commission, which is more or less the same issue that was raised by Uwa there, which we reflect on the second column. What is the relationship between the Competition Commission and the Transport Economic Regulator there? There's a detailed information to differentiate between the two, and we've provided some sectoral regulators which we have learned from the CASA, NESA, and so forth. Sure. Okay, basically raises a point in relation to fundamentally shifting from this object when it focuses on other overall substantive of policy development competition regulation. The issue of Competition Commission is covered under the establishment of Transport Economic Regulator. The issue of safety comes in on ensuring that safety is not compromised in the process of making regulatory decision, which is one of the questions that was asked in the previous presentation as to do we also include safety regulators in this bill? The answer is no, we're not considering safety regulators there. We're only focusing on economic regulation. Yeah? And yeah, price control, we've dealt with it. The regulator, I'm looking at Free Market Foundation Chair. The regulator is not a constitutional institution of any sort and should not be afforded powers to intervene in disputes that fall under the purview of the judiciary. The answer, in short, Chair, we also creating a council or Transport Economic Council, which will deal with, which will be seen as a tribunal, deal with disputes and appeals. So the regulator's role is purely administrative, and therefore there's no need for that argument. Chair, let's see here. So okay, Chair, Sasol basically says the bill should take into account alignment with the principle of integrated planning, which is purely why we having an integrated single transport economic regulator, ensure standardization and ensure that there's a uniform application of economic regulation in the transport sector. Yeah. Okay, the issue here is around information accessibility raised by Western Cape Department of Transport and Public Works. The comment has been noted, and there would be alignment of different acts that deals with promotion of access to information. There, it's noted point. Let's see. Let's see. In the main, there would be comments, particularly from Western Cape Department, Uber, Transnet, City of Cape Town, and Railroad Association. Outer, we've highlighted the fact that they support the bill in its form and shape and are looking forward to this process. Okay, Transnet's argument is around the price control, as well as the fact that the powers of the price control is in the hands of the regulator, which surely is the focus of the regulator. Its main functions to deal with price control matters, and hence the point is very critical, the Chair. In conclusion, Chair, obviously we indicated that we support the bill and yeah, and the rest. Thank you, Chair, for the opportunity. I think that's where we can stop from our side. Thank you, Chair.
Thank you, Ndatesi Kudo. Members, I think deliberately I wanted us to refresh ourselves where we are. Let me see hands in terms of deliberations now on this ERT bill of transport. Honorable Hansinger.
Thank you, Chairperson. Chairperson, I would want to concur with what I think my colleague, Honorable Mangu, anticipates. And that is that there are comments and input that should not be handled, in the way that one would play tennis. In other words, that the ball simply gets hit, as if it's a once-off opportunity to reply to an attempt to be part of the development and design of this very important ERT bill. What I mean with this is so little of the content, so little of the intention, so little of the actual idea of what the department aspires to achieve is known and was known at the time of what was published for comment. For instance, there was a lot of comment around the Competitions Commission, and the general answer which was presented now by Mr. Sikudu was that there will be no competition between the future ERT and the Competitions Commission. It's no issue, they will work concurrently. So I've got the direct question then, because in visualizing the future where you would have a continuation of the Competitions Commission as well as a ERT tribunal, what if somebody approaches both of these institutions simultaneously at the same time? What mechanism in this bill will handle that process in making sure that there is concurrence at the end of the day? So what in the current bill suggests any form of mediation or streamlining so that there aren't two processes with two at the end conflicting judgments or rulings? There's nothing in the current bill. So the critique around a situation of conflict is not one which lines up the Competitions Commission against the future ERT, but it is comment that addresses the various issues. So therefore, Chairperson, I think the comments should stay alive. The competitions should, the comments should not be ruled out in the way that it has been presented to us now. In a question and answer session of this is relevant, that's not relevant, this would be taken serious, that would not be taken serious. This is a process. It's a process of legislative development which has to be in a process of development and involvement, but then on the basis of full information and full plan and full idea, which we as the legislators, the politicians involved in developing this legislation, we even don't have all the answers. We even don't have the full picture of the ERT bill. So I think, Chairperson, there should be a session where at least we get to know the full idea and intention around this ERT bill with all the information. And I would strongly suggest that we then recirculate what we have at that stage for public comment, because this is nothing more than a framework that we are now debating with very little flesh around the actual framework. and we do need the finer print and get rid of this high-level thing and get to details, because this is a very technical piece of legislation. Thank you, Chairperson.
Thank you, Honorable Lansinger, Honorable Lawrence MacDonald, followed by Honorable KP Stolle and Honorable Mangu.
Thank you, Chair. Chairperson, I'm a little bit concerned, Chair, that this bill is actually at the end of its life. It's actually, the department can't change much in what it's proposed in the bill, but we'll work towards putting our inputs into the bill, Chairperson. But I mean, looking at what was just presented, and I mean, there was a comment about the e-hailing, that they support the bill as long as e-hailing is not as long as e-hailing is excluded from the regulation, Chairperson. I mean, there's some serious pitfalls in these comments, Chairperson, that needs to have a thorough scrutiny to make sure that this bill, when finally done, actually does the people of South Africa some good. And Chairperson, and I feel for Transnet. Transnet has already priced itself out of the market because of over-regulation. And now to add additional regulation it's going to kill that state-owned entity, Chairperson. So I think I'm also of the view these comments, Chairperson, must be taken serious, and we must we need to go through these things and maybe I don't know, Chairperson, the right wording, but I think we need to just give 5 minutes step back and let's just go through this thing properly and make sure that everything that is said and everything that needs to be taken in consideration is taken in consideration, Chairperson. Thank you.
Thank you, Honorable MacDonald. Honorable Stolle Ketamabala.
Thank you very much, Chairperson. Chairperson, I think the purpose of receiving the submission is to get their ideas and respond according to what they thought and what they think, so that when the bill is out there, everybody is owning the bill. But I'm worried, Chairperson, when I check the response from the department, it doesn't seem that they are trying to address the response from the comment or submission from different entities. That's my worry, Chairperson, because even if you check the submission from outer, if you remember, Chairperson, there was a lot of criticism that were put forward by outer, but it doesn't seem that it was catch up on this response. If they say they just support the bill, actually, I don't think that's a true reflection of what happened when we was listening to them. And the other, Chairperson, I'm trying to check the issue of Western Cape, because if you check the issue of Western Cape, there's a lot of things that's supposed to be looked at that were submitted by Western Cape, because the other department and the municipalities. Because if you check the response doesn't give us some idea what actually going to happen. Because if they are talking about further, they are going to further negotiate with them. Actually, it's not a good idea. And we must try to observe what the submission was, so that when we are dealing with the page-to-page bill, we know what was the submission all about. And then the last one, Chairperson, is that one, the submission from the different municipalities, there was nothing except the Western Cape. I still have a concern because that bill does not only talk to Western Cape, it talks to all spheres of government. So if you can actually get an idea, what is their only input on that one? And the last one, Chairperson, is that one of the taxi industry, because there's nothing that's been said or submitted by taxi industry. Thank you very much, Chairperson.
Thank you very much, Honorable Member. Let's take Honorable Manu.
Thank you very much, Chairperson, for your indulgence. Well, without raising a ping-pong issue, maybe let me put my original concern in context and maybe suggest a way forward. I can see your face, you are frustrated, Chair. One, before the department went out or consulted, there were obviously a couple of submissions they received and so forth, which at the time they would have had an opportunity, I believe, to incorporate in their bill before it comes to Parliament. I think that is what in the main one was referring to. But again, as was responded to. But what I want to suggest, Chair, which I was hoping we would avoid, is that the bill is now ours, and we need now maybe to take it head on, tedious as it might be, not chapter by chapter, but word by word or sentence by sentence. As we do that, we will be able to pick up what were the comments and make our input to do that amendment. And I believe that the parliamentary legal support is in the meeting. They will be able to be taking notes. Let's accept that the department has done what they wanted to do or that they could do. And I don't think we will get anything more from the department, with due respect. Not that they don't have it, but the process now is ours. Let us go to it, Chair, line by line. And then we will be able to move forward. Where we end, we will continue until we sort it out. That will be my proposal as a way forward, having listened to the department's response. The issues that Honorable Ketamabala is raising, we had raised the issue of consultation broader, but it doesn't really assist us because we don't have those answers. We have a bill in front of us. My strong proposition, and I think this is where the chair you were going to or asking us to go to, is that we take that bill as it is presented in front of us, we read it line by line. Chapter by chapter might not be enough. Let's do it line by line until we finish it. Thank you, Chair.
Let me just say, I've heard all the members' comments. And I think at this point, we should agree, honorable members, that our business of the day today was to deliberate on this ERT bill of transport and make our amendments and agree on them and move where we think we need to amend. Something is not sufficient. I think this is an opportunity afforded to us. And I think Honorable Manu has captured that correctly. When I gave members an opportunity, it was indeed to try and do that. I know that parliamentary legal advisor May Kanjin is here, and state law advisor May Haricharan is also here. So it's correct that we have all the people we need here to make or insert our amendments in terms of what we see would take this bill and take the country forward. That is actually correct. I think we should then begin to go line by line to deal with these issues. And that's what I am awaiting from members. Honorable Manu is correct. Can I see hands in that regard? Honorable Stoll, is your hand up? Or you forgot to lower it? Okay. I see the hand of Honorable Hansinger. Is there any other hand? Let me see. Take us on this matter. I see one hand. Honorable Manu. Maybe let's start with those two hands. Moving forward. Honorable Hansinger. We are at your mercy, sir.
Thank you, Chairperson. Chairperson, I support the proposal by Honorable Mangu. On condition, Chairperson, that we do not forget that we are still in need of a detailed overview at low level, not high level, of the financial implications, also including the HR issues and the legislative issues, given that the ideal way of dealing with this is in a phased-in approach. So, Chairperson, I support Honourable Mangu's suggestion, but then on condition that we still need to see a very detailed presentation.
That resolution we have already taken, Honourable Member, and I think we are ready then to move forward. This proposal by Honorable Mangu has been supported. Thank you. Honorable Mangu.
Thank you, Chairperson. I'm trying to maneuver between the gadgets here, and I don't think I'm willing to be able to have the bill in front of me and what I want to talk to. And I hope you will have my, and you will indulge with me on that. I will raise a few issues. I don't have specific recommendation of how to phrase it, but hence I mentioned the legal people who are here. What came out very clearly, and I think in our deliberations, were the issue of the PAIA and POPIA Acts. It was very evident in most of the things that we received, and I think some members did agree that there is not much emphasis on that that PAIA Act and the POPIA Act, so that we know how do they interface with this piece of legislation in front of us. The second issue, and again, as I apologize up front, I'm unable to say where it should go into in that particular draft that is in front of us. The other issue that came out very clearly, and I think it links to what Honorable Hansinger has just said and what Honorable McD had said in the previous meeting and early today, is the funding mechanism of the regulator. I think we should find a way in the bill where it is explicit, if it is legally allowed, to say clearly how this is going to be funded. And I think that will be supported by what my colleagues have earlier said, questioning the proposition of the department that will be saving or not saving. Number three, the issue of the Competition Commission and the regulator has come out on numerous occasions. It is my submission and view that the bill should be explicit in terms of clarifying that particular role of the regulator as it relates to the competition, so that there is no ambiguity as to which one would supersede the other one in whatever legal authority or hierarchy is there. And I hope that I am quite clear in my submission. The other issue that was raised a lot by commentators, people who submitted, of course, I'm not sure if it can be legislated. However, it was the issue of accessibility of this regulator. Given the scope of the infrastructure that it seeks to regulate or get involved in, the structure, and again, I think it links to what my colleague, Honorable Hunsinga, was saying, as it relates to HR matters and finance matters. I'm of the view that some form of explanation of how this regulator will operate or positioned or situated could be able to assist. Yes, Chairperson, I think, as I said, I didn't go to say that page, this one, but those were the overarching issues that I would ask that as colleagues, we consider with the assistance of the legal support of Parliament, if my comments are legally sound, and if they are, how could they be incorporated in the draft bill as it is presented before us? For now, Chair, I would like to pause there, and given maybe as we get traction, one will be able to input further. Thank you, Chairperson.
Okay, thank you, Honorable Manu. Let me, at this particular point, allow any comment if there is a comment from the two legal advisors, Ms. Kanjin or Mr. Haricharan. We'll come to you, Honorable MacDonald. Legal advisors.
Good morning, Chair and honourable members.
Yes, ma'am.
I'm Philoshni Gangan from Legal Services at Parliament. I've heard the members have had...
How do you pronounce your surname?
Gangan.
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 Thank you very much.
I've listened to what the members have proposed, and I'm more than happy to assist in going through the bill systematically with members and to offer any assistance that I can.
Okay. Thank you very much.
Thank you.
Thank you very much. Mr. Haricharan,
Just trying to...
Okay. We don't have him here.
I am here. Morning, can you hear me?
Yes, I can hear you.
Yes, sorry, my apologies. I just have a bit of problem with my video. I am here. It's Ms. Raksha Haricharan from State Law Advisor's Office. Chair, I also have, I'm more than willing to assist the committee with any inquiries that they have. Yes, we're willing to proceed. Thank you, Chair.
Thank you very much. Honorable McDonald.
Thank you, Chair. Chair, on Section 50 of the bill under finances, there is Section 51, subsection A. It says annual fees paid by.
Before we go to the sections that you are going to take us through, I think the procedure here will be for us to test the proposals by Honorable Manu and agree with them, then move forward to any other proposals.
I am in agreement 100% with Honorable Mansu's suggestion that we can start from sentence to sentence down the board, Chairperson. I've got no problem with that, Chairperson.
He has put in issues like the role of the competition and the regulator should be clarified and other issues. Do you agree with them?
I'm in agreement with him, Chair, on what Honorable Mansu has said. What I was about to raise was adding to that, Chairperson.
Okay. Let me check before you add. Any member who does not agree with the proposals made by Honorable Manu, let me see a hand. In the absence of a hand, I think of hands, I think Honorable McDonald has supported the proposals, and they stand as the committee's proposals. Honorable McDonald, you can now move to make your own proposals.
Thank you very much, Chairperson. As I was saying, Chairperson, under Finance 50, it's 50 of the bill, one subsection A that says the annual fees to be paid by the regulated entities as determined by the Minister in terms of Section 51. But then under C, it says any other fees payable in terms of this Act, Chair. Now, Chair, as much as the annual fees is very well explained in Section 51 under in this Act, the other fees in terms of this Act is not so clear, Chair. So if we can have a better explanation of what the other fees payable in terms of this Act can be, Chairperson, or I might be reading it wrong, Chairperson, but that's my submission, Chair. I think it needs to be explained a little bit better.
I think that will be done as we receive a detailed presentation of this. Maybe let's say if the department is here and can hear us, we should be able to get that by next week, so that we conclude this part. Honorable McDonald, any other thing from you?
No, I'm covered, Chair. Thank you very much.
Thank you. Any other hand, honorable members? Honorable Manu.
I hope it doesn't become a table tennis between me and you. I think the colleagues from internal state law advisor in Parliament are being very, very cautious in their approach, which I respect. They don't want to accept our powers. So I thought we'll do it line by line. Maybe I was being too ambitious, and the suggestion you had started with earlier was chapter by chapter. Maybe as we continue, because I'm just scared that my next input might take us to chapter 5 and the other one to chapter 3, and then we are forward and backwards. Maybe as a further suggestion, what could assist us, maybe if the legal advisors or even our content advisors can say to us, chapter 1 deals with the following. Summarize what chapter 1 is dealing with, and thereafter, through you, Chair, if we agree to say to us what are our comments on that chapter, we would have had a summary of what chapter 1 or whatever the case may be deals with. Are we happy? Then we go to the next chapter and so forth and so forth. That hopefully could put us in a more systematic way, Chair, because I still have comments, but as I say, they are not captured in terms of chapter 1 or chapter 3, and we might do a ping pong. Thank you, Chair.
Thank you, Honorable Manu. Thank you very much. I think what you are saying takes us forward. Advocate Nell.
Morning, Chair. I just want to check with Chair if we need to flag the bill on the screen, or what I would suggest, Chair, especially the issues, some issues that the department indicated in their presentation, where it's almost a simple amendment to make, like consequential amendments or grammatical corrections. If the committee agrees to the grammatical corrections, those types of amendments, clarification of definitions that might have needed, those are, it's almost a technical aspect, but something that can be done a little bit easier, so that we have some information for the legal advisors to have to already incorporate into the A list. Then we get into the nitty-gritty of if we look at a clause and we say the committee's fine with this clause, then that clause won't go onto the A list, it'll stay in the bill. But if we have some aspects that we need to change, perhaps there needs to be a better definition of, let's say, whether e-hailing services are included or not. That's something that the committee will then deliberate on based on the comments received, or if there needs to be clarity on what transport mode or field will be regulated. Members will recall the department did indicate that for purposes of this bill, the safety aspects are not regulated. So railway safety regulator, that was brought up in some of the comments, they, for example, won't be incorporated into the economic regulator system. So if we can get agreement on those types of comments and clarity, that's where the deliberations come in with members. Then, Chair, if we need to flag the bill, or at least if I need to flag the bill, I'm going to have to just take some time to change my connection from my phone to the computer and put the bill up for members. Chair will just guide me on that.
You are correct, Advocate. Can we hear me?
Yes, Chair.
Yes, you are correct. Let's proceed.
Okay, Chair. I just need some time from my side to get the document set up and change my connection share. That will probably take me about 5 minutes.
It's okay. It's okay. We can probably take a bit of a break. Those who wants to go and drink water for 5 minutes, let's do so.
Thank you, Chair.
Chairperson, can I ask a question?
Yes, sir.
I'm surprised to hear that the railway safety regulator is not included in the intention of the single regulator. Have I missed a submission where all the entities that would be included is listed? Or was this just an example? Because that's part of what is not clear. And why isn't this said?
Your question is directed to the department.
Through you, Chairperson, yes.
Okay. Honorable Ntenza.
Thank you very much, person, and thanks, honorable member. Mr. Sikudo, would you please address that question? Through the chair, please.
Mr. Sikudo.
Yes, Chair, I'm still here. Thanks, Mr. Tenza, and thanks to the Honorable Hansinger for raising that question. Maybe let me take you back 2012, maybe it will help to understand the approach here. The initial conception was to have a super regulator, which would have all the regulators in the transport sector housed in one institution. And we then had to look at what is working and what is not working. What we found when we then developed the discussion document was that current safety regulators in respective subsectors of transport are functioning very well. Let me probably disaggregate this. In the transport sector, when you go to aviation, there would be a safety regulator and an economic regulator. From the economic regulator point of view, you have the regulating committee that regulates prices and charges in the aviation space. Then you would have 2 licensing councils, which are part of an economic regulation. The distinguishing matter here is that there would be a civil aviation authority that for its competency is on safety. So we then distinguish the two within the aviation sector. Then we go to the rail sector. In the rail sector, we currently don't have an independent regulator. Transnet plays both the role of the independent regulator as well as operator. So there's a conflict there which we're trying to resolve. Then the safety regulator is purely on safety related matters. So we don't categorize that regulator under rail. Then similarly, you would have in the maritime sector where you have SAMSA, which is a safety regulator there. Then you have the ports regulator of South Africa, which is an economic regulator. So we separate the two. So in real terms, project concept, the safety regulator seems to be functioning well, and there isn't any major problems with that. Where we need to focus the attentions of the department and resources and focus, it's on economic regulation. So on the listed economic regulators that we're considering to consolidate, safety regulators, including the rail safety regulator, is not part of the problem. That's really where we're coming from, Chair, you know. So you could list, like I've done with the safety regulators within different subsectors. Obviously, I haven't mentioned the road, but the road has safety regulators, RTMC, RTI, those would be categorized under safety regulators. Then you would have the economic regulators would be your national public transport regulator, you know, the cross-border road transport agency. Those are economic regulators, which would form part of the bill when it is phased. It is basically implemented on a phased approach. I think hope it is helping to the honorable members here. Sorry, the one point that state-owned entities like Transnet, those are regulated entities. Those are the entities that we aim to regulate. Yes, you raised the point around charges to Transnet seem to be overburdening economic regulation of transport and all that stuff. But if you disaggregate divisions of Transnet in different sectors, it's a different ballgame as to whether that is the case or not. Thank you.
Thank you. I nearly said advocate. Are you advocate, sir? Okay. Okay.
No, I'm not the advocate.
Okay, no, thank you. Is advocate Nell back?
Chair, I am ready to flag the document, but I see there's quite a few hands up, Chair.
Honorable Hansinger, you want to make a follow-up?
Yes, thank you, Chairperson, and I appreciate the opportunity. And thank you, Mr. Sikudu, for giving us this insight. Chairperson, can we then get such a document that would give us clarity on which entities or portions of entities are considered to be included in the ERT, recognizing that the intention is for a phased-in approach, but just so that we also have insight in the different functions and roles that would be included within this economic framework and not safety framework, because until now, you know, there wasn't clarity about this, yet we have circulated a bill for comment, and certainly the comments would have looked different. Thank you, Chairperson, but we desperately need something on paper that shows us what Mr. Sikudu just said.
Honorable Manu.
Chair, no, I apologize. I misbehaved. I should have dropped it earlier.
Thank you very much. Mr. Sikudu.
Thank you, Chair. I think that's another good question as well. The product that we have before Parliament has been supported by a number of researches that were conducted. And those researches resulted to local and international benchmarking exercises which was done. The bill was informed by a critical document which will answer an honorable Hansinger's question, which relates to options analysis. There were various options which were looked at, and that document details each options and why we opted for this approach that we have as an output before you. We are willing to share that document. We could also share the draft business case document that we have, and it will help for the honorable member to be informed. Okay. Thank you.
No, thank you. Please do share. Advocate, can you continue now?
Yes, Chair. I'm going to put the bill on now. Chair, can you see the bill?
Yes, I can see, Advocate.
Is it large enough?
Interpretation. Am I reading it correct?
Yes, I just made it a little bit bigger, Chair. Chapter 1 is on the interpretation, purpose, and application. So these will state the different definitions that the new bill seeks to bring in. Bearing in mind, this is a whole new bill. It's not an amendment of an existing bill that the committee has been used to. So what I would suggest, dear members, consider the comments. If members look at the department's presentation document, where they also took an approach where they worked in an orderly fashion and addressed some aspects or issues regarding definitions that needed to be clarified. Then members can give their input there for our legal advisors, just to include if we have additional definitions that we need, then we can put that in. Members will see here, for example, Competition Act just refers to the Competition Act. That is also where the whole Competition Commission queries came in. Just quickly going through here. So just to refresh members of all the definitions that they have here. Another refreshing regulatory authority. There were some comments regarding whether or not the bill will be applied to municipal authorities and their ability to regulate transport in terms of the Constitution and the powers that they have. And then as well as how the act is to be interpreted. That is the chapter 1, part A. I think I'll pause there, Chairperson, for members to just give their input if they can just refer on their side to the document by the department.
Thank you, Advocate. Members, anything on definitions? Are we fine with the way the definitions are?
Chairperson.
Yes, let me. Honorable Mangu.
Thank you very much. I think in principle, I am in agreement with what is before us. However, the question would be more than commenting on what is in front of us. There were concerns raised on previous occasions on because after an act, a bill becomes an act, there's a lot that happens behind the scenes through regulation. Now, whether there is a need to define what regulations are here, so that the concern that was raised, although I don't recall that there was an agreement from the committee point of view, subject to correction, obviously, is whether we need to specify here that process of regulation. We do talk about the regulator, who it is, and all those things. Would it be wise to put in, Advocate, what are regulations? Well, it says regulations made in terms of this act. But the question that was in this committee before was the process that might elude or evade this committee in terms of having sight over those regulations. Again, I'm speaking, maybe thinking aloud, is that overreach, or should we leave it at just saying what are the regulations without saying as promulgated or as determined by the minister or by the minister through parliament, something to that effect. Thank you, Chairperson.
Thank you very much, Honorable Manu. Honorable McDonald.
As I'm lowering my hand, Chairperson, thank you very much, Chair. Chair, there is in the definition annual fee, which means, which I've just explained in my previous comment, but there's no definition of other fees, Chairperson. So I'm concerned, Chair, that if we don't specify what those other fees could be, that we could be, there could be a trap in the future, Chairperson. So I'm just asking, Chair, again, I'm not a legal person, Chair. I'm just an ordinary person from the Free State, so I've got no idea. But my gut feeling says that we have to specify the other fees, Chair. Thank you very much.
Thank you. Before we conclude on this one, let's take advice. Any advice from the legal advisors? In terms of the explanation of regulations and this one of fees?
Chair, it's the Loshni Gangan.
Yes, ma'am.
Just regarding the definitions of regulation, I'm satisfied that regulation made in terms of this act would sufficiently cover regulation in terms of this act. And then in terms of definition for other fees, I'm just thinking aloud that if we're going to limit ourselves with regards to what fees it is, we just need to think about that. So they've specified what fees we can charge, and then the other fees is just the catch-all. It really is up to the committee if you want to limit that definition.
Honorable members, what are we saying in terms of other fees? Honorable Manu?
Chair, I'm back on my issue of regulation.
Yes, yes.
I think the response is a generic one, which I fully understand and I accept. I think that is what many pieces of legislation would say. However, I premised my input to say there was a concern raised in this committee about regulation that could be passed that the committee doesn't have sight of. So in other words, there would be things that could be done there. Now, the question is it possible that regulations come back here, or it is not the purview of Parliament and its comments when it comes to regulations? If that is the case, then I fully agree with it as it stands. However, if there is space for committees and Parliament and its committees to have sight over regulations before they are published, then that is what I would propose the committee advocates for. So it was in that context, Chair, that I raised the issue. And on the issue that Comrade Honorable McD raised, I think we should try and be more specific there, because you will find that most of the time there are concerns raised. For instance, I will raise an issue later around the determination of prices. So the issue of finances here, we need to zoom into it very closely, or fees or anything that relates to money. Thank you very much, Chairperson.
Thank you, Honorable Stole. Honorable Stole.
Yes, Chairperson. I was checking on transport sectors, Chairperson.
Oh, let's finish this one first.
Okay.
Honorable members. Hello.
Chairperson, my hand is up again, Chair.
Honorable McDonald.
Chairperson, Chairperson, I think that we should rather oversubscribe what the fees mean. In other words, we must clearly put the fees there, because, Chairperson, if we don't do that, we're going to get a situation where, and I'm going to just thumbsuck something, that a stupid fee could be thought of, that you must now pay carbon tax on your tires, for an example. That would have severe impact on certain industries, Chairperson. So, Chairperson, we need to specify the purpose of the bill, because this bill is supposed to regulate the economic regulation of fees chargeable and ticket prices and etc., etc. So if we don't specify the other fees properly, Chairperson, we are leaving ourselves for the interpretation by a person later on, years from now on, that can interpret this thing completely differently than what we are interpreting it at the moment, and add as any fees that they were. And I think that it would be an injustice if we don't specify exactly what we mean with other fees, Chairperson. That's my final submission on this part. Thank you very much, Chair.
I think the first issue by Honorable Mangu, if I'm correct, deals with the issue of our role as a committee in terms of regulations. Am I correct, Honorable Mangu?
Yes, Chairperson, you are correct. You are correct.
Would I be correct to say your view was that in the definition, that should also be clarified?
That is correct, Chairperson. Hence, I started by saying, if it is legally allowable that we have a role to play, we would like to play a role as Parliament and its committees on the production or processing or finalization of any kind of regulation. Yes, Chair.
And if that question is appropriately answered, then that will also cover the concern of Honorable McDonald of other fees. Because if, for an example, any other fee has to come, it would come via a regulation that will also via through the committee. Am I correct, Honorable McDonald?
You are correct, Chair. You have summed it up correctly, Chair. Thank you.
Let me go back to the advisors on the specific issue of the role of the committee when it comes to regulations by the department. At a particular stage, the regulations have to come through the committee, not only this bill, but I think that is a view on all the regulations that the committee might be might find itself interacting going forward. Mayor Gangen and Mayor Harry Cheren.
Sorry, Chair, I was on mute. Hello?
I can hear you very well.
Oh, I'm sorry. Apologies for that. Chair, I've looked at the clause in the bill, looking at regulations,
Yes,
and
yes,
it
ma'am.
says, sorry, just bear with me. It's at the end of the bill, clause. Just a moment.
If I may help as to where exactly the clause is, it would be after clause 50, if I may, Chair.
Yeah, that's correct. It says that the minister makes the regulations. I just want to read that exact clause. It says on the effective date and for a period of 60 business days after the effective date, the minister may make any regulation contemplated in the act without meeting the procedural requirements, and it refers to section 54 or elsewhere in the act, provided that the minister has published those proposed regulations in the Gazette for comment for a period of at least 30 business days. My understanding, Chair, is that the regulations are within the purview of the minister, and that we do not necessarily get to deal with the regulations.
Thank you, ma'am. Are you finished?
That's my input. If any of the other legal people want to add or comment, they're obviously welcome to do so.
The minister can deal with the regulations and complete them without the committee seeing them. Is that what you are saying, ma'am?
That's my understanding, Chair.
Okay. Okay, let's hear Ms. Haricharan.
Thank you, Chair. Chair, I agree with my learned colleague from the Parliamentary Legal Advisor Services. Regulation clause 4 does state that the minister may make regulations, and he is empowered with this. He is given this power by the draft bill, and we are in agreement with the Parliamentary Legal Advisor. Thank you, Chair.
Thank you very much. I think this that suffices. And then let's go to the issue of Honorable MacDonald. Do you have okay? Honorable members, let's deal with that issue of Honorable MacDonald so that we can then deal with definitions. Honorable MacDonald's view is that when it comes to this issue, there should be specifications. We shouldn't be saying these fees and other fees. What are members saying? Let me take the hands that are there.
Honorable Chair.
Honorable Ketamabala.
Yes, Chair. I'm agree with the Honorable MacDonald, because if you check the tariff, it says, where is it now? It says means any charge. It means any charge, fee, toll, fare, and other amount that may be imposed by the regulated entities for the use of or access to or any transport service or facility. Actually, if you check that one, it actually doesn't specify what kind of tariff we are talking about. Thank you, Chair.
Honorable Mangu, you want to say something?
Yeah, no, Chair. Yeah, I think I'm in between too many gadgets. I keep on forgetting. No, Chair. No, thank you.
Thank you very much. Don't forget Honorable Stolle. Honorable members, let me just check with legal advisors on this matter. At the level of the law legislation, what would be the best possible way is for us to limit ourselves if there comes a space or avenue to increase your fees as a regulator. If we specify these fees, wouldn't that then necessitate a new process of legislation? I'm just checking the best way of handling these fees. Let's hear from legal advisors, Ms. Haricharan and Ms. Kangen.
Chair, may I please just clarify your comment? Are you saying that if we are specific in this bill, it would make it difficult for any future amendment bills? I just want to understand.
I am saying if we specify that fees will be charged on the tariffs, whatever, maybe 3-4 issues. And tomorrow, the department sees a need to charge a fee on
Chair,
any
you're
other
muted.
issue outside the specifications, the specified issues. Wouldn't
Chair,
that?
sorry, you were muted in most of your input.
Wow. Am I still
No,
muted?
no, Chair, you were not muted. I think there's a problem with Honorable Mangu's connection, Chair.
Oh, my apologies.
Okay. Maybe for the benefit of everybody, I was saying if we specify maybe 3 issues where fees can be charged, and tomorrow there is a need of any other issue beyond the specified issues for fees to be charged, wouldn't that necessitate a new kind of legislation?
Thank you, Chair. That's exactly what I was alluding to. My concern purely is that if we're going to specify the cost, the term other costs, we are going to limit ourselves for future. And so from that point of view, I wanted to leave that open. Just in terms of exactly what you're saying. Chair, sorry, if I may, I just have one other thing to add about the earlier definition, the regulation. May I quickly?
Yeah.
Sorry, Chair. So my understanding is that the Act allows for the minister to make these regulations. And this is as the bill is drafted as it now is. Of course, we could, if the committee wanted to possibly change that, I think it's something that could be looked at, to say that Parliament can play a role. So I think it depends on how the bill is drafted. Ordinarily, we ask the minister to come and account to the committee as part of its oversight duties. And in any event, the regulations are published for comment and we can then have input. But as far as I understand it, if the committee wants to add that, then on my understanding, it can be done. But
If the
sorry, Chair, as the bill is now drafted in its current form, it says that the minister does it, and it doesn't speak about consultation with the committee.
So your view is that that could be added, that before finalization of the bill, the minister, the regulation, the minister must consult with the committee.
That's my understanding.
Wow.
We can ask the state law advisor if she is in agreement or not.
Thank you very much. State law advisor.
Yes, Chair. I'm in agreement with the parliamentary law advisor, Chair. Thank you.
Thank you very much. If you are in agreement, then Honorable Manu's suggestion was that we should add that portion whilst we are here. Am I representing you well, Honorable Manu?
Chair, you are correct. And I want to thank the colleagues for reconsidering that, because we find ourselves in problems as oversight because things were happening this way before. We don't have the guts to say, why can't it change? So yes, I'm happy because the portfolio committee must for always, whether we are here or not, play a role, fully oversight. So I'm fully in agreement. That is what I was suggesting, Chair. Thank you very much.
And that will then cover the concerns of Honorable McDonald. Let me just check agreement on this suggestion that that we should put such a clause while still in the definitions. Any seconder?
I second that proposal, Chair, but I also would want the definition of other fees included, Chairperson. I'm very strongly in support of my motion, Chairperson.
Didn't I hear you well, Honorable McDonald, that the inclusion of this particular clause in particular gives the committee an opportunity then to interact with any other fee as it is included? Because I'll tell you why I'm saying so.
Chair, I will submit, Chair. It's fine, Chairperson. If it's subscribed better under that regulation, as Honourable Manchu has alluded to, Chairperson, I submit and I am happy with that amendment. Thank you, Chair.
Thank you, Honourable McDonald. Let me see any hand that does not support the inclusion of this law as suggested by Honorable Manu. Anybody who does not support? In the absence of any hand, this becomes an agreement by the committee. Advocate, can we move?
Chair?
Yes, Advocate.
I just want to indicate to the committee that the discussion about the committee having input on regulations is in each of our bills. I was trying to find some of the past documents, but it's a little bit difficult while I'm sharing a screen to pull up some of those other documents. We have not, since we've done some amendments, we have not changed the clause on the regulations to specifically say that the regulations must come to the committee. But if the legal advisors are willing to look at that or just get an opinion on that, then the committee will be refreshed with that. On the tariffs, yes, annual fee is there in the definition. The definition on tariff is specific to the regulated bodies. So that definition on tariffs is not necessarily the regulating entities' tariffs, but the use of other tariffs, as indicated, it's part of the regulation, so it can be covered in there. The regulations will most probably include what other tariffs are. It's something that's movable and that does change. And when they do come out in the regulations, the public do have chance to comment on those. So if it is a proposal that's going to come forward that might have a severe economic impact on the regulated bodies, they will make their submissions at that point. So hopefully it will cover the concerns that Mr. McDonald raised. I know Mr. Sitole mentioned something about the transport sector. I'm not sure if he wanted to make a comment on the definition or specific to the clause, but Chair, I'm just moving over to, we have the interpretation of the Act here. So it does indicate what other legislation has to be considered. I don't know if the question that Mr. Manko had on PAIA and POPI that was raised in the submissions, if the legal advisors can indicate whether or not addressing that information sharing aspects that we received in submissions could possibly be covered by adding interpretation to information under this clause, or if it will be better suited elsewhere, Chair.
Thank you, Advocate. Let's hear the legal advisors.
Thank you, Chair. I think the proposal by Advocate Nell is very important with regards to the confidential information and the information referred to in the bill. So I think that what we could do is we could include and just broaden under the interpretation section with specific reference to the specific legislation that deals with the information and the transmission and sharing of. So we can work on including a definition that would cover the existing legislation as well, such as PAIA and POPI. I'm not sure whether the state law advises in agreement. Thank you.
Chair, yes, Chair, we are in agreement with the parliamentary law advisor in that regard. Yes, we are. Thank you.
Thank you. Thank you. Back to you, Advocate.
Chair, if I may.
Honorable Manu.
Yes, thank you. I wanted to also maybe remove one of the things I was going to raise under clause 13 in the context of what the advocate has said and the other colleagues are agreeing, that if they could also look at clause 13, which is dealing with access to information by the regulator. I think as you consider broadening in the interpretation, please consider clause 13, and I will not raise this comment again in clause 13 so that we could, because I found them to be linking. Thank you very much, Chair.
Thank you very much, Advocate.
Okay, Chair, the next part of the bill is the purpose and application, part B. As we saw in the summary that the department presented, even though there's some conditions on the support of the bill, majority of the submissions did support the objects and purpose of the bill. It could be for members just to take some time and look at 3.1a, for example, where we have reference here to the transport industry. And then we have B talking about the passengers and goods, then by air and the ports, road and rail. This is where some of the submissions came in and they needed clarity on whether or not their specific sector will also be regulated in terms of this bill. For example, the e-hailing guides having a concern. Some of the concerns presented by Transnet regarding the freight aspects and whether or not the regulation will be between the freight tariffs by rail versus freight tariffs by road in order to make them competitive with each other. So Chair, that's just linking the comments to the purpose of the Act. And then as well, the next one is the application of the Act. It's just to make sure on the application side, we had some comments there by the Western Cape government indicating that they needed clarity on whether or not this Act, once enacted, will apply to or affect their rights to regulate transport within the municipal sphere and set their tariffs there. One can also go so far as looking at concerns of whether or not the regulation will also be on municipal buses, for example, the Joburg Metro buses or the Tshwane Metro buses, and then go further into the BRT buses, Chair. So that will be these two sections, linking them up with some of the comments that we received. And then again, there's also the linkage here to the Competition Act and the market inquiries there and the reference to the Competition Commission. So this is where those concerns should be looked at, Chair, by the committee.
Thank you, Advocate. Let's hear from members. I see two hands. Honorable Ketamabala Stole and Honorable Mangi.
Honorable Chair, mine has passed. We remember that I was on transport. So
your hand is still up, sir.
Okay. But I didn't talk on it.
Remove your hand. Honorable Mangi.
Thank you very much, Chair. As I lower my hand, I welcome the comments by Advocate Nell there, which I think are very, very appropriate. So my proposal or my suggestion, because there's quite a lot there that she has highlighted that requires us to apply our minds. Maybe it's one paragraph that we could consider coming back to if Chairperson agrees. But my point on the purpose of the Act was simply, I don't know whether I expect some things to be too clear. We are dealing about an Act that is establishing a regulator. But nowhere in the purpose of the Act do we highlight that particular issue of the establishment. I don't know if it is the wrong place I'm looking at, because the Act seeks to establish a regulator. That is the purpose of this Act. And on top of that, that Act then will deal with the other issues that are raised there to promote access and so forth and so forth and so forth. Is it not the right place to highlight that it is the establishment of this regulator there, which will then obviously do what is attributed there? Okay, I see Advocate is highlighting D, establish appropriate institutional arrangements and procedures to support. Yeah, I think it's very muted there, Advocate. But I see what you're highlighting. That was my point, Chair. I thought it would be the first issue, that this act is seeking to establish this regulatory entity, and therefore, yeah, then it will continue in line with what the Advocate was proposing there or suggesting to us. Thank you, Chairperson.
Thank you, honorable members. Any member who wish to say something whilst we are still here? In the absence of the comment, I think members indicate that they are fine. Advocate?
Chair, just while we are on this aspect, I don't have the department's document in front of me right now. I just wanted members, if they can, on their devices, just go to the department's input that they made in relation to the Western Cape government's comment on when we go to the application of the Act, but also on in terms of the purpose of the Act and what spheres will all be regulated. If members agree with the department's comment, they on what transport industries, for example, will be. If there's agreement with the department's view, then that is basically as it is in the Act, and we can carry on from there. But because I'm just trying to assist the parliamentary legal advisors in getting their list together for members' input linked to the submissions. Then going on to the application of the Act, Chair, just again going back to the comments from the Western Cape government, if members can just have a look in how the department made the explanation on the regulation of transport modes that do apply within the municipal bounds, and just get the committee's view on which way they are either agreeing with the department or stronger agreeing with the Western Cape's view, just so that this will also assist everybody that had made submissions and that are looking at the process to know exactly who and which sectors and spheres are incorporated in the Act.
Thank you. Are you done, Advocate?
Yes, Chair, just for these two clauses, if we can just get that clarity, then we can move forward, Chair.
Thank you very much. Let me go back to the honorable members. I can see the hand of Honorable Chris Onsinger.
Thank you, Chairperson. Chairperson, just reflecting back on the submissions that we had and the reference to the Competition Commission, wouldn't it be wise to, in this portion, also give clarity on the role of the Economic Transport Regulator and the role of the Competitions Commission? So that it's clear in the objective what the distinction is and the difference between the two in the objectives already.
Is that all from you, honorable member? Don't you want to have a bite on what the advocate has raised?
No, I'm in agreement with what she said, Chairperson. Thank you.
Thank you. Any other hand?
Chair, my hand is not up. I do want to have a bite, just that as the advocate was saying, I'm also juggling through a lot of documents. It was in front of me. I don't know what I did with it. The issue of the Western Cape government and what the department was saying there. Unless, Chair, without delaying the meeting, that I could be allowed, if it's fine, just to document them if I've got anything and forward them, maybe even before the meeting ends. Because I just went out of that document, I was playing with it around, looking for something else, and now it's delaying me to go back there.
No, it's okay. Let's take, in the meantime, Honorable McDonald, and give you some time, Honorable Manu. Honorable McD.
Chairperson, thank you. Chairperson, I'm in agreement with what Advocate Nell is saying, and specifically some of the comments that were made. Chairperson, I'm not 100% sure how to phrase it, but I think we need to have a very clear indication in this purpose of the Act of who are affected, who are these entities that is affected, specifically the taxi industry, the e-hailing, and a couple of like the municipal bus services, etc., so that everybody is clear on who is affected by this bill, the purpose of this bill, Chairperson. That's my submission, Chair.
Could you also comment on or support on the proposal made by Honorable Hansing, the clarification of the role of the competition?
Yeah, I'm also in support of that, Chairperson. The role of the competitions board regarding this bill, because otherwise, in my humble opinion, they would be conflicting each other, Chair. Thank you very much.
Okay, let's then at this particular point check. Oh, Honorable Manu.
I am ready. I am ready, Chair.
Thank you very much.
Thank you, Chair. I'm confining myself to the submission by Advocate on her proposal whether to consider what or not. My concern, if we limit ourselves or we define specifically the definition of facility, which I think is some of the things that were raised by the city of Cape Town, I think it confines us. I don't know what kind of facility that could appear tomorrow. Maybe tomorrow we'll have flying taxis and they're landing on top of roofs. I'm not sure if we limit ourselves to that. So one of the issues they were raising was defining the facility itself. And I think their comments were more limited towards the taxi ranks and so forth and so forth. So it might take us back, but maybe there could be a consideration of defining properly or broadening the definition of what a infrastructure or transport facility is. I think it would cover most of the areas that were raised there. Now, the issue that I think is very sensitive, and I don't have an answer, but I don't think we should blind ourselves to, and maybe the legal team could assist us here, is that transport is a concurrent function. And the concerns that are raised in the particular reference that was made by Advocate Nell of those powers of the minister vis-a-vis those of the MEC and transport, I think it is a valid point in the context that transport is a concurrent function. Therefore, you don't want to create unnecessary tension at that level. We are seeing that tension already in the RTMC, that in the RTMC law enforcement is not allowed in the Western Cape, for instance, because the MEC of transport there rightfully says, I will need to give you permission to come here. So you can drive the whole Western Cape, you won't find the so-called National Traffic Police. And I think this is where the functions, the concurrent functions, are going to come in. So we don't want to allow a situation where the minister's powers are extended beyond those of either the municipality or the province. I think we need to have clarity there. I don't have a suggestion, but I think in terms of maybe the application of the act, it says, for instance, if you push it up a little bit, Advocate, I want to read two particularly, 4.2. Thank you very much. It says, where did it run to now? When I was our Advocate, you hit this thing now. Application. Thank you, Advocate. Yes. It says, in application of the Act 4, subsection 2, the minister, in consultation with the regulator, by notice in the Gazette, may declare that this act applies to any market or any entity or facility, irrespective whether privately or state-owned, within the transport sector, if the minister has determined that either the following circumstances apply, blah, blah, blah. I think that is a very, very dangerous clause, given the concurrency of the transport function. And I made the example of Western Cape now as it relates to the RTMC. It could be anybody tomorrow. I think we should look at that one very closely. And those will be my comments, Chairperson. Thank you so much for indulging me.
Thank you, Honorable Manu. At this point, I wish to request the committee to allow me to suggest that concerning this bill for today, let's hold it here because we need to be out here by 12 o'clock. Am I correct, Valerie?
Chair, you can continue as long as you can until 1 o'clock, but if you want to adjourn before that, it's also up to the committee.
Okay, we can continue up to 1 o'clock. Okay, no, it's okay. Thank you very much. I think we have that energy to do that. Advocate Nell?
Okay, Chair, going to chapter 2, which has the specific view over rail infrastructure. Just to link this chapter, members will have to just have a look at the input received from Gautrain Management Agency, as well as the input received from Transnet. Clause 5 deals with the determination of access costs and review of access agreements. Considering access agreements, Chairperson, there are different views around public-private partnerships, or for example, the issues that the committee has raised in the past regarding, for example, the rental agreements between PRASA and Transnet. Just to give members an idea of how the practical applications could come in, as well as some, because Transnet, for example, requires a rental or a fee if PRASA has to access their rail links. There's some issues in their agreements where in some instances, long-distance passenger rail train will have to wait for a large freight train to come through first before the passenger rail train can continue. So that's the type of practical issues that we see today, and the regulator will hopefully seek to address these types of tariffs and access agreements. So 5 is the access agreements and costs. 6 is the types of access requests and access fees. 7 goes on to the content of access agreements and notification thereof to the regulator. 8 goes to requests for and consideration of access approval by the regulator. So the regulator will, in this instance, play a larger role in those types of agreements. 9 goes into the decisions on access approval, and 10 goes to the cession, transfer, or assignment of access rights. I'm just not sure, Chair, whether or not the department's view on the access side is for the rail infrastructure, the actual rail use type contracts, or perhaps also contracts for in access to rail precincts. For example, if we look at Cape Town Central Station, the different vendors, if they're going to go that far, I'm not sure. Then we also have the rail reserve, which is the land bordering the rail lines. One can make an argument that access agreements to that kind of property aspects could also be covered, or if they are actually just looking at the actual transport service, which is on the rail line infrastructure. Chair, the department might give some input here, but for members to consider in these ones really is the comments made by the GMA, Gautrain, and then Transnet.
Thank you, Advocate. Department, do you wish to give a comment before I allow members to make their inputs or amendments?
Yes, Chair. I think the last part of Advocate Nell is correct. Say the focus of this chapter is purely on rail infrastructure and rail services. It does not relate to the vendors and so forth, Chair. So it's specifically on rail infrastructure and services. Chair. Thank you.
Thank you very much. Let me then see hands. I can see Honorable Manu's hand. Over to you, sir.
Thank you, Chairperson, once more. I would really like maybe Advocate to repeat herself. I might have missed it. Maybe let me be specific. What is this chapter 2 saying, Advocate, in simple language as it relates to infrastructure such as the Gautrain infrastructure? Because that will be the future. Because unfortunately we have allowed our own infrastructure in PRASA to disappear in our eyes. So if we want to resuscitate rail in this country, your Gautrain type of structure is going to be the future, whether we like it or not. Now, what is this chapter 2 saying as it relates to the future that will happen and the current in the form of Gautrain? So, Chair, if I may just get that clarity, I was trying to follow Advocate as she was going through, and I missed it there. I just want some simplified clarity. Then I would have a substantial input. Secondly, I don't know anywhere else, it might be there, where we are talking about access to other infrastructure that we are defining under this act. Remember, Transnet had raised rather the issue of pipelines and so forth. Are we going to discuss that later? But for now, let me confine myself to this clarification of rail infrastructure in the context of the current Gautrain infrastructure and what could be in the future. And then, if possible, Chair, I could then make my substantial input. Thank you.
Honorable Stole.
Honorable Chairperson, I'm trying to check on that access to rail infrastructure. If you check, there is that, I think it's number 4, where it says any infrastructure owner must launch all existing agreement. I'm trying to check that should be may or must. And the other one is on top there. They are talking about must within 1 year from the date of determination contemplated in subsection 1, any infrastructure owner must review. I'm trying to check this infrastructure owners must review or must launch. I'm trying to check the must or it should be may or should. I don't know if they can actually make me to understand that one. And the other one, Chairperson, I'm worried about that one of number 2, when it says all entities that immediately before the effective date had access to rail infrastructure will continue to have such access rights in terms of the existing access agreement. If they can just unpack us to understand the logic behind that one. Thank you very much, Chair.
Thank you very much. I think let me go to advocate at this moment. Honorable Mangu had requested the advocate to clarify some issues that he has mentioned.
Okay, Chair, I think the department can give a bit of better clarity in terms of the policy view and the rail policy view, because we are still going to get the rail bill. They've worked extensively on the policy and where they want to go to. But the arguments that we did see in the submissions regarding Chapter 2 and the impact it might have, if we look at the access agreement aspect, and I think this will address both members' issues, or at least I hope so. The may and the must will, our legal advisors will come in terms of legal drafting, where and why that is required, but members are always open to give their input on those. The access agreements, Gautrain has access agreements and they've got a PPP with Bombela. This allows them to have that partnership of that consortium running the infrastructure, or running the train line on the infrastructure. The need to protect the current access agreements will be that issue, as well as a possible need to protect access agreements that Transnet have, their ones. But the Act will envisage, as I understand it in terms of policy, to allow for possible future agreements that can allow private rail services as well. An example of some of the private rail services that we do see is the Blue Train, some of the Rovos rail, some of the older steam train type setups that we have here, for example, in Cape Town, from Cape Town towards Ceres, where you have the steam train. It's private bodies that then have access agreements to run those train services for that specific tourist type service. So this will allow those agreements to remain in place and to make sure that all those agreements in terms of 5.4 get sent to the regulator, so that the regulator can then have a look at it. Gautrain Management Agency, if I recall correctly, they had some concerns regarding how the setting of tariffs might affect long-standing or long-term agreements that are in place. Those long-term agreements are normally also brought in to make sure that the persons that do come onto the services have the long-term agreements in place for funding and more secure backup for their funding. So that is how I understood it would affect Gautrain. The view is, if we do bring in more services or more high-speed type services like Gautrain, we can envisage the services that has been a SIP2 project for many years, from Joburg to Durban, where there was talks of some Chinese companies coming in and having a look at possible tenders. That has died down a little bit in recent years because of the other aspects that have taken over. But Chair, I think the department, in terms of how they see this being applied on their rail entity PRASA, they might give a very a better view there. In terms of the pipeline issues that Transnet raised, the pipeline issue can be seen as something that lays within road or rail reserves, but the actual pipeline itself might fall under the petroleum industry, where that situation is regulated even though you can also go in terms of it is, in essence, a freight type service that also comes in, but that is a very specific service. So the department can just give their views on how the submissions that we've received, if they agree with those submissions, if they fall within other legislation, or just give clarity on how they see the rail policy going forward, Chair, and how this clause seeks to advance that.
Thank you, Advocate. Honorable Manu.
Thank you, Chairperson. Yeah. Yes, I think it just it deepened the crisis, the response by Advocate. It deepened the crisis. I went very quickly as Advocate was responding to my request through you, Chair, to the definitions to try and also establish what is it that we are defining as rail infrastructure or infrastructure, and I couldn't find it. I know we have gone through the regulations, but it was of interest at times when I don't understand what a clause is saying. I try and go related to what the regulation, or rather the definitions were saying. So I tried to go through what I have here, and I couldn't find a definition of that. So that then brought me to the question whether it should not be something we should be considering defining specifically this rail infrastructure, because we have a clause that is dedicated to rail infrastructure. Now, going back to chapter 2, particularly where you are, Chair, I seriously have issues with this clause, and but I don't want to problematize it. And again, here is an investor comes and puts in rail infrastructure, and at their cost and everything, after they put in their clause, now Rovos want to use their rail. Now the regulator must come in and determine the pricing of what Rovos Rail or Blue Trade must pay on that. That is my interpretation, and I find it a bit problematic if it is correct. Now, one of the issues here, it says, there was something talking about effect. Yes, clause 2 says, all entities that immediately before the effective date had access to rail infrastructure will continue to have such access rights in terms of the existing access agreements. I'm not sure who has these access agreements other than PRASA, Rovos, and all those things. So, Chair, I find this whole clause a bit challenging to me. Maybe I am been thinking too much. Let me leave it there and say maybe I'll apply my mind further rather than delay the meeting. But I find it very, very interesting clause. But if I'm correct, maybe my specific request could be for consideration of defining this rail infrastructure or infrastructure in its broad terms. That might include rail. Thank you, Chair.
That is your proposal, Honorable Manu, as I hear you. Although we are now on the access to rail, let me just check. What will the advisors say? Ms. Kangen and Ms. Haricharan.
Thank you, Chair. I'm more than happy to look at specifically defining rail infrastructure as proposed. So that's something that we can definitely look at.
Ms. Haricharan.
Chair, I agree with the parliamentary legal advisor. Thank you, Chair.
Honorable members,
Chair,
anybody?
Chair, if yeah, Chair. No, I think the colleagues from legal must speak their mind. You know, they will help us. They must not be too sensitive. Because while we are looking at access to rail infrastructure, I'm raising an issue that just pops in of definition. Now, yes, I hear them saying they can look at that, but my concern of the lack of the rail infrastructure definition, does it have any bearing, negatively so, on the chapter we are looking at? So that they give us a full context, you know, and I'm pleading with them to be honest, to say, yes, we can look at it, but actually, in terms of chapter 2 here, it has got no bearing whether there is a definition or not. You know, we need that type of honest opinion, then we will be assisted. Thank you, Chair.
Thank you, Honorable Member. Honorable Hansinger.
Thank you, Chairperson. Chairperson, I would also want our legal people and colleagues to just look at this particular chapter 2 with the 3 subsections under 5 in the following manner. Starting off with sub 2, where it says that all entities will continue to have access rights. Then in sequence 4, which says those that have these rights must within 1 year furnish their determinations to the minister. And then 1, so after a year, they have 1 year to then furnish those agreements to the regulator. So then only the minister can make a determination. So from the onset, there is at least 1 year's delay. Now, if at that point where the minister then says, listen, I've given you 1 year to furnish me with your existing agreement so that I can take a determination, if at that point this owner of a particular section, according to 3, says, well, I haven't taken a review of my existing agreements, then that owner has another year to do the review of the agreement. So it can delay the whole process with 2 years before the minister can make a determination.
So what is your suggestion, Honorable Member?
To amalgamate Transnet and PRASA and not use this bill to gatekeep a current bad setup of more than 1 billion rand being cross-invoiced between the 2 entities, Chairperson, because that's how I see it. That this act will ultimately become a gatekeeping regulation, which would complicate the current situation instead of taking a decision to amalgamate Transnet and PRASA. Because what we have here in Chapter 2 is a regulation of the tariffs and fees between the very awkward relationship which we currently have between PRASA and Transnet, instead of amalgamating the 2 entities. So in terms of this, Chairperson, I'm trying to be constructive and involved, but it's really difficult because I really thought that the regulation would be a step towards getting PRASA and Transnet together and so that we can fix rail, and not as a type of gatekeeping mechanism which now clearly sort of evolves. So yes, sorry to sound negative, but I'm rather disappointed because I thought this would be the mechanism to bring the 2 entities together. Now it seems it would be a gatekeeping mechanism.
Okay. Any input from the legal team, Ms. Kangen and Ms. Haricharan?
Thank you, Chair. Just with regards to what the Honourable Member Manku said, I just want to be clear. The committee has agreed to go through this bill line by line, and what I am doing is I'm literally taking notes of the concerns raised by the various members with a view to comprehensively look at the bill, the concerns raised, and then cross-referencing it to the other submissions received. So my intention is to completely give a full comprehensive response when we meet again with regards to the concerns raised by members. So it's just a little bit, I'm finding it a bit challenging looking at the document that Advocate Nels got on and having all the other documents open at the same time while trying to provide a response. So all I'm asking is if we could be allowed the opportunity, because the points that are and the concerns that are being raised are very valid, and we'd like to provide a comprehensive and a succinct response. And I'm just asking for the opportunity to be able to do so. Okay. So that's my intention. I've noted it, and we will look at it in depth, I assure you. Thank you.
Thank you very much, ma'am. Any input from Ms. Harcharan?
Chair, yes, I'm in agreement with my colleague again. We would like to provide good inputs here, and if we afford the opportunity to look more closely at the issues raised, we'll be able to better reply. Thank you, Chair.
Is that also in connection with what Honorable Hansinger has raised?
Yes,
Chair,
Chair.
I just
Sorry.
Yes.
Go ahead, Loshni.
So just with regards to the clause 5, I've taken a note of what the concern is, and we will also respond to the Honorable Hansinger.
Okay. I think that settles this issue. Members, there were two proposals that I think we need to see if the committee supports them. The first proposal was by Honorable Mangu, a more broad definition of the rail. What did you say? Rail what, Honorable Mangu?
Chair, it's rail infrastructure, Chair.
Rail infrastructure.
Yes, Chair. Thank you.
Yeah. Let's check support for it. Any seconder?
I'm fully supportive of that, Chairperson. Thank you very much.
Support.
Support. Honorable Keta Mabala.
Actually, I'm not actually not supporting it, but I'm worried. What is our status on this thing? Because you see, if you check that once the minister has determined, and you check 1 year from the date, I'm trying to check if that 1 year lapse, what is going to happen? No, because I'm trying to understand this accessibility of this infrastructure.
No, that is the second proposal. by Honorable Hansing. I will come to it, Honorable Stolle. I hope you hear me. Let's deal and finish with this one of Honorable Mangu. Any member who does not support the proposal by Honorable Mangu? So that becomes a committee's proposal. We are all in agreement. Honorable Hansinger?
Chairperson, as I understand it, the current consideration is whether a rail infrastructure should be included as a definition. In other words, we should define what rail infrastructure is. And for that, I'm in full support.
Yes, I was saying, would you be so kind to repeat your proposal?
Chairperson, my proposal is to take a review of what is mentioned in Chapter 2 as 5 sub 1, 2, 3, and 4, especially around the years. Because if you read it in a sequence from 2, where it says that all entities have a particular right of access, and that upon a decision or the determination of the minister, these agreements must be submitted within a year. And should at that stage, the owner of a rail infrastructure say yes, but according to subsection 3, I have not done a review. That owner then gets a year for the review. It can add up to more than 3 years before the minister can make a determination.
Yeah,
so I would suggest that we look at this again, because there must be a remedy, because deliverance can cause a delay, which is definitely not the spirit of what is intended here. So that we should look at phrasing it in a way so that there is a remedy upon a deliberate delay, which can happen in the way that this is written and structured.
Okay. Thank you very much, Honorable Hansinger. Any support for this proposal? Let me see hands or hear people talking. Supported. Mkhayes. Any come again, another one?
I'm thirding it, Chair.
Thank you very much. Anybody who's against this proposal, let me see a hand. It means it then becomes a resolution of the committee that we should look into this.
Chair, we are a united committee. We never disagree on issues of substance.
Thank you very much, Mkhayeso. Yeah. Advocate, can we move on?
Yes, Chair. I'm sure the legal advisors will just have a look with the department on the various definitions of rail infrastructure that there is in other legislation. They might use the old ones, or they might look at considering the new ones that will come in with the rail bills that we will see hopefully later this year or early next year. Then I think what will help with this 1 year running is to see whether or not they run concurrently, or whether the one will exclude the other. They will, I'm sure that can be addressed with wording. Chair, then we move to chapter 3, unless the members wanted to consider some of the other clauses up to clause 10.
Let's move to chapter 3. We'll allow them if there's anything that we are leaving behind.
Okay, Chair. Chapter 3 goes to the economic regulation of transport facilities and services on price regulation. Chair, this is where it's a slight conflict with the previous one. I can understand if Chapter 2 looks at the rail infrastructure and the actual on-rail services itself, but Chapter 3 then now goes broader. So it's not that this Act doesn't look at the facilities at all or the possible rentals. It's just that that section of it will fall under Chapter 3 in terms of my reading. Here we get the determination of price controls in clause 11. This could also affect existing agreements unless the existing agreements are carried on because those rental of facilities may be for longer periods than they then might be anticipated. It might not be a yearly agreement. It might be up to 7 or 10 years. Just going to clause 11 is quite long, Chair. So this will look at how they have to consider the setting of those tariffs, those fees, looking at annual adjustments. Then there are extraordinary review of price controls. This is under Part A. Chair, I would suggest we look at Part A before we go into the information issues here under clause 13, where we had some other issues. This price control concerns could also could affect the operations, or the setting of these price will affect operations at minibus taxi terminuses, the aerotropolises, the large airports, the rail infrastructure, rail rentals that we get, for example, with Prasa Crest, could affect AXA's revenue that they do get from their rentals and advertising. It might also affect advertising. So all of those aspects can be looked at. Chair, I think we'll look at Part A on the price controls for the facilities.
Are you done, Advocate?
Chair, I think if we can do Part A first before we move to Part B and just get members' input here, Chair.
Thank you very much. Members' input. Honorable Mangu.
Chairperson, thank you. Thank you, Advocate. Well, my input is that this chapter, in my broadest sense, interpreting it, is talking about even determining the price of what I pay at Avis and what I pay at Imperial. So that will also be regulated. Somebody could please just confirm if I'm right or wrong. And you would notice that that particular sector, if you want to, in fact, it will even determine the price that a tourist operator charges me to take me to Mapungubwe and all those places. So if I'm correct, I think it is quite broad and it requires thorough understanding. But my major input here is it came up also in the public hearings, just that I couldn't get to that comment quickly so that I could be specific. Because currently SANRAL determines their rates of tolls. Now, this means therefore that SANRAL, despite their long-term concessions they have with Bakwena, N3TC, whoever else they are considering, will have to be subjected to the regulator here to determine the price of that, and that power is taken away from them. If I'm correct, and I'm here, I'm trying to clear my mind, to get what is the understanding. What therefore becomes the role of Sandra, or what is the impact, economic impact, rather than the role, if my assertion is correct. So I'm seeing this determination of price controls being amongst the most controversial clauses here, that we should make sure that as we look at it, we are not compromising, for instance, the role of Sandral to determine their prices or to collect what is due to them in line of their concessions. Chair, I don't have a specific proposal, but I'm trying to get my understanding clear on what this price regulation clause A, as advocate is saying exactly, so that we understand its implications. Thank you, Chair.
Advocate.
Chair, I think this one will be better explained by the department, if they can just give clarity on what they envisage for this, because we can read it as it is, but we need to know what the department seeks to achieve with this clause, Chair.
Isn't it that the department and this bill seeks to regulate everybody, including Sandral, in terms of price setting? Maybe let's get it from the department's view. Let's hear the department.
Honorable Chair, it's Mweketi Sukuro here. I'm happy to respond to some of the questions and comments made. The comment to say that the price control regulation would be applicable to all entities within the transport sector, which would include Sandral. But the price control or prices that we are looking at regulating, it's not so much about accessing or renting a car from Avis or so forth, but it's so much about accessing the infrastructure related to airports and airplanes. For example, there's a regulating committee now that determines the prices charged by airports to the airlines. Those are landing charges which are charged by the airports, and the role of the regulator is to basically determine what exactly should be charged. Obviously, indirectly, what has been charged by AXA to airlines would have an impact to the overall price, tickets, and so forth, which will then have an impact to the prices that customers would pay, but in exclusions of car renting companies like Avis and so forth. And Mr. Mango mentioned an issue around tour operators. Indeed, the economic regulation would play a big role there in long term, because in long term, from this regulator, we are expecting to incorporate the National Public Transport Regulator, which currently regulates the charges of tour operators and so forth. Chair. And with regard to Sandral, particularly, which will give us guidance, is that we have agreed, as the spirit of this bill, not to interfere with the current long-term agreement, concessions or PPPs that are being managed by Sandral or any other entity within the transport sector. Those cannot be tampered with because those are contractual arrangements. But any other new long-term agreement which would be entered into, at the beginning, there's a scope that we have created for the regulator to be one of the participants to see if what is agreed at that stage, it's something that would be feasible and would be acceptable for the benefit of the public interest. So Sandral's current price determination, indeed, as the Honorable Mango has indicated, it's within the portfolio of Sandral, subject to approval by the minister. So the component that is sitting within the control of the minister to approve those charges or tolls of Sandral would now be transferred to the regulator, because we've understood that the minister currently doesn't have sufficient capacity to provide oversight to determine calls by SANRAL. So that component now would then be transferred to the regulator, because we anticipating that the regulator would have sufficient capacity, sufficient technical know-how to analyze whether what was it agreed and anticipated by SANRAL is correct. That decision has no implication in the portfolio of SANRAL, and there has no implication in the issues of investments and the role of SANRAL to manage road maintenance and road management. So we didn't see any negative implication there. On the whole, is that the bill under section 4 says those who are regulated now will continue to regulate. It therefore means an acceptance of the bill. Price control regulation will apply to those. Whenever a minister decides to include BRTs, include terminal accessibilities as a way to regulate them, then this section will then apply to those as well. But at the current moment, when the bill is enacted today, those who are regulated will continue to be regulated, and the new ones will be included in the list for regulation based on the conditions which were stated there, such as 70% monopoly, such as whether the environment is uncompatible and should be made compatible. I think I will park there. I hope I have responded to the questions and comments.
Thank you very much. Honorable Hansinger.
Thank you, Chairperson. Chairperson, I think it would also be of benefit to request at this stage a list of all the current transport entities that would be subjected to these price controls, so that we know who are we talking of, who will be affected. And then more specifically to the section that we're looking at, I know that in this particular section, there is a 15 days. There's a disturbance which I'm experiencing, Chairperson. Can you determine where this disturbance is coming from? Thank you, Chairperson. This disturbance is gone. Chairperson, there is a 15 days period in which a submission can be made for intervention, and after that 60 days for a review. But there is no indication what happens, because it is premised by a may. If the regulator then in 60 days does not do this, what further action can the submitter of a price deviation then make? Thank you, Chair.
What do you want to suggest, Honorable Member?
Chairperson, two things. One is that we get provided with a list of all the transport stakeholders that will be affected by this section around price control. Mm-hmm. Secondly, with particular reference to 11, which is highlighted now, that a consideration and specification be done around the implications of the portion in this section that says the regulator may, within 60 days, review the impact. Now, if the regulator then does not do this, what happens? What further action can the submitter of a price deviation then do to get the regulator so far as to do this? There's no indication of what further action a submitter of a inquiry into a price deviation can do.
Thank you very much, Honorable Member. I take it that Honorable Mangu's hand is up. Honorable Manu, I take it that your hand is up.
I dropped it sheepishly. I didn't even want to apologize this time.
So you're still on holidays, eh? It's okay. Let me see hands that agree with the proposals as laid by Honorable Hansinger.
Agree.
Mhlonishwa. Ngakubona ngathokoza. Any other hand supporting? Baba Keta Mabala, I can see your hand is up. Okay, thank you. Any hand that is against the two proposals? Thank you very much. So the department will then provide us with the list of all who are affected by these decisions, and the consideration and specification will be done as put by Honorable Hansinger. Any other issue whilst we are still here? Any hand that I'm closing out? Thank you very much. Let me request, as I've requested earlier on, that we stop here for today. Morgen nog een dag op hier die item. Ons zal verder gaan morgen. En luister naar die achtbare leerders. I wish that we should then, with your permission, members, pause on this item. As I've said, we'll continue tomorrow. And invite everybody that needs to be here tomorrow on this matter. But finish other items on the agenda because of time. Am I getting your support on this?
Supported, Chair.
Supported, thank you very much. Any vehement or violent disagreement on this issue? None, thank you very much. Op hierdie oomblik ek wens dat ons moet item 2 toe gaan. Item 2, as I've indicated, will be dealing with the request by the department for written submissions by this committee on the civil aviation policy. Advocate, I know there is a letter that all members have, and at the bottom of that letter of invitation, there are questions that we need to deal with. At this moment, I will request Advocate to help us deal with this matter and lead us so that members can have their inputs. Advocate, are you ready?
Chair, yes, the department is looking at policy review on the civil aviation. If members recall, when we looked at the Civil Aviation Amendment Bill, there were some comments on the definition of air services and why we're looking at it now, because there's a new air services bill coming, and members will recall in the strat plan, I also highlighted the air services bill versus the air services licensing bill that might come, that was in the department's strat plan. So they are looking at their policy considerations, and they just wanted some input from the committee on what policy issues they could include that the members have raised. And if members look at the email that Valerie sent them, I just listed a few points that came up in discussions, both the previous committee as well as this committee, related to airports. The concerns or the issues I've raised here, I'm just going to read them for members that might not have it in front of them. The members did indicate that there was a need to assess all airports or landing areas in the country that are not currently operated and managed by AXA, especially in rural areas and local or district municipalities, to consider whether these can be taken over or operated by AXA to promote aviation opportunities outside of large metro areas, as well as the use of aviation for transport to assist in reducing road traffic. That was one consideration we saw in last year's strategic plan, where our members raised that. The second one is that there's a need to assess and ensure that there is greater transformation achieved in the aviation industry. I just listed this transformation needs to be from levels of pilots, air stewards, ground crew, navigation technicians, infrastructure suppliers, and value chain, etc., that's linked to the aviation industry. This has come up in quite a few discussions, as well as the oversight that was done to ATNS and AXA itself, where members noted that there is a need there as well, raised the massive matter with SACA, that we do need to see a bit more transformation there. The third one, a need to improve on the safety measures at airports to prevent follow home or criminal incidents near or at the airports. The next one is a need to promote aviation-related educational programs in the basic education phase of students throughout the country, and promoting access to aviation schools and or courses from metropolitan areas to rural areas, including possibilities to train to become pilots, ground crew, air stewards, air navigation technicians, engineers, airport infrastructure developers and builders, airport designers or airport management, etc. There was also a need to assess the current business opportunities of vendors at airports to enhance airport revenue, as well as allowing more small business enterprises to obtain opportunities to rent stands or shops at airport facilities. There was also a need to cooperate with other modes of public transport to ensure that our airports are designed or allow for all modes of transport to link up with the airport in a coordinated manner to reduce overcrowding and route disputes amongst public transport operators. This can be seen as OR Tambo being a good example of where we have a rail station going into the airport. We have taxi services. There's not necessarily long distance bus services linking up with the airport at this point in time, but that could be in the view or the proposals of the Aerotropolis. And we have the BRT services going to Cape Town Airport, but not necessarily a train service. So in order to get proper integrated transport facilities, that would be a good policy move to head towards. And then the last one I listed is that linking up with Aerotropolis is that there might be a need to consider the possibility of creating more Aerotropolis type airports. The only ones we have currently really is the King Shaka International Airport and Dubai Trade Port, but that could be expanded even further. And there are plans with the city of Ekurhuleni and OR Tambo International to turn that into a true Aerotropolis in the sense of the definition. That is one of the plans that are in Gauteng's 2035 transport strategy. So members, those are just a few that I listed from the engagements over the years with members. If members have any other policy input that they might want the department to consider going forward, this will be what we need to include in the letter to the department, Chair. Thank you.
Thank you very much, Advocate Nell. There are members who are very passionate about this aspect of transport. Remember that we are submitting to the department as they have requested, I think this is a good gesture that we must properly utilize. At the moment, I'm going to give one of the members who is a pilot by profession, Honorable Lawrence MacDonald.
Chairperson, thank you very much. Chairperson, the autonomy of the Accident Investigation Board in this amendment of the bill is a big concern, and there was a lot of people making comments regarding the autonomy of the board and how would it function, because the way that it's presented in the bill, it seems that it's going to be a player and the referee at the same time. And Chairperson, I think if the department can just clarify us exactly on how this structure is going to be autonomous within the broader structure, it would also assist, Chairperson, because, you know, Chairperson, those 3 young people that died in the mountain there in George, working for the Civil Aviation Authority, that accident has not been resolved, and those are the type of things that we need to address, Chairperson. It can't take years to finish an accident, because the longer you take to investigate an accident, the easier it is to miss critical things. As a matter of fact, there are other planes of the same airframe currently flying in South Africa. What if there is an inherent serious safety issue with that airframe, Chairperson? It means that a whole 2 years will be gone, where people will still have been flying those airplanes, and we have not concluded the investigation, Chairperson. So I would really like that the department give us a little bit more meat on that. Thank you very much, Chairperson.
Is that the only submission you have, Honorable Member? I thought we'll get about 5 from you.
No, Chairperson, I'm happy with everything that Advocate Nell has submitted. It covers the broad strokes, Chairperson, except for what I have just mentioned, Chairperson. Thank you.
And without sounding preemptive, I may think if you have spoken, the whole committee have spoken, let me test my view. I was wrong. We have Honorable Manu, we have Honorable Hansinger. In that order, honorable members.
Thank you, Chair. No, you were very right. Just that as a committee, we like enhancing one another's inputs. Chairperson, firstly, I welcome and I think we should support the broad framework that Advocate has given to us, given the past experience and inputs. However, if we could maybe find it in writing, because I think it's a bit too broad in terms of many things. I've got 3 specific issues that I would like to submit to the committee for consideration. The first one, Advocate talks about the operation small businesses on the land side or on the facilities of the airport. I think there is more lack of transformation on the air side part of it. Your tags that are there, you have your Swiss ports. It's only recently now we see some Menzi. You don't even know who's owning this Menzi. I think that policy there needs to cover both land side and the air side. Now, I think, and I'm not sure that the department has a clear policy as to the running and everything of these privately owned airstrips, stroke airports, and maybe even at times the municipal run ones and so forth, because there are municipalities that are running airports. And I'm saying it in the context that some years back, we had mercenaries that were arrested in Harare. They were en route somewhere into Africa, but they're taken off here in Vonderboom Airport, landed at Polokwane, cleared internationally, and off they were. So I'm of the view that there need to be a tightening of the policy framework in that space. In the same way that the department wants to control the economic regulation space, the department must control the airports. They are a big source of entry and exit in this country. And I'm sure we don't know everybody who enters and leaves this country. My third point is that there is a very, very rigorous process of approval of international stroke regional airport status for airports. I think the department is playing a very low-key role there. And I would like to see that policy being beefed up with timeframes. I know of a municipality that applied for a status, but it has taken more than 10 years without even a response, whether the application is successful or not, or whether what should happen. So those are my three concrete proposals that I'm submitting to the committee to consider in what the advocate has already said. Thank you, Chairperson. You are muted, Chairperson. This time you are really muted.
Thank you very much, Honorable Manu. Masitholo olandelayo, Tatu Hansing, ithuba ngelakho. Tatu Hansinga.
Thank you, Chairperson. Chairperson, I'm in full agreement with the 7 points which Advocate Nell has submitted, also the 3 points of Honorable Mandu, and the content and which Honorable MacDonald shared with us. I would want to add a point related to the fact of a aviation crash and the loss of life or injury thereof, and the importance of such an incident triggering an inquest automatically. The situation that we currently have, just to motivate this, is that the family is left without any answers. Even after the completion of an investigation, there is no obligation under the current framework of legislation to notify the family of what exactly happened in a crash. And I would imagine that we should be responsible, but then also accountable, and then also obliged to explain to the family what actually happened in an aeroplane crash. And therefore, I would submit that consideration should be made to include a clause or a reference where an inquest be triggered automatically upon the loss of life or injury of a plane crash. Thank you, Chairperson.
Thank you, honorable members. Be always in the mood of lowering your hands after you have spoken. That will assist us in moving forward so that I don't repeat members. You covered, Honorable Manu. I think these are the submissions we are making to the department. Advocate.
Yes, Chair. I'll just draft those points For chairperson, I'll include the issues raised by members today. Just try and find a way to include them, because I know the concerns regarding the autonomy of the investigation board is still part of our discussions under the Civil Aviation Amendment Bill. The same for the request by Mr. Hansinger for the automatic inquest process. That was also one of the things that were under consideration in the Civil Aviation Amendment Bill that the committee will still also deliberate on. So if we're lucky there, we might address those issues before it comes in another piece of legislation. But for purposes of being as complete as possible, I will include all these comments in a list, draft letter for chair. And then chairperson can have a look and sign off for the minister.
Thank you very much, Advocate. Thank you once more. Honorable Hansinger, you were talking about a meeting of Thursday. Which Thursday are you talking about, sir?
Chairperson, on my diary, I've got a entry which was loaded, which indicates a portfolio committee for transport, public hearings from 1400 to 1600. Whereas the time slot on the Outlook is entered as 9 o'clock to 1600.
That is this Thursday.
It's this Thursday, the 4th of February, chairperson.
No, because our agenda has the 2nd and the 3rd, but let's hear what's happening there on the 4th. Valerie?
Chair, there is no meeting on the 4th. The last meeting for this week is tomorrow. I think maybe Mr. Hunsinger's PA, who received the draft program, already slotted those meetings in. If members may recall, I've indicated that those public hearings will have to be shifted because of the members training. So that will only take place on the 16th and the 17th of February. I will just resend the updated draft program again to members. But I always include the PA and executive secretary so that they know what's happening. I will just also send them a reminder so that they know not to slot in those meetings as if it's confirmed.
Thank you, Chairperson. Thank you, Secretary.
Thank you very much, Duncan. Let's now deal with the set of meeting of the 26th of January. I'm sure members have gone through the minutes. Any hand proposing adoption of the minute?
I propose the adoption. I propose for the adoption. Honourable MacDonald to propose for the adoption of the minutes, Chairperson.
Seconded by Honourable Ketamabala.
Yes.
Peter Stoll. Thank you very much. Any matters arising from the minutes of the 26th January? Nothing. Can we move to the minutes of the 27th of January? I'm sure members have gone through the minutes. Any proposal for adoption of the minutes? Babu Stoll. Babu Ketamaba.
I'm proposing for the adoption of the minute, my friend.
Any seconder?
Seconded, Chairperson, Honorable Manu.
Thank you, Honorable Manu. Any matters arising from the minutes?
Zip.
Nothing.
Chair, from my side, there is no issue. I just want to confirm before the meeting adjourn that the committee confirmed the date for the department to respond to the matters raised as this morning for the 10th of February.
Can we give the department 7 days to respond? Is that proper? Honorable members, are we agreed? Valerie would support.
Yes, Chair, supported.
Thank you very much. Any other thing from you, Valerie?
Chair, no, that is all for now. I just want to sensitize members that an application has been made to House Chair for the civil aviation hearings to be conducted on the 16th and the 17th of February from 9 till 1 o'clock. I'm following up today to hear the response, but in the meantime, I will forward a draft program to members to see how those 2 days will unfold.
Angibonge ke malunga ahloniphekileyo, wendlu ohloniphekileyo futhi. Isikhathi ke sesindlulile sokuthi singabe sihleli kulendlu yesishaya mthetho. Ngithanda ukuthatha leli thuba ngibonge ke kini nonke, sihlangane futhi kusasa kusukela ngo-9 ukufikela ngo-12. The meeting is officially adjourned. Thank you to everybody. To those
Long
that
live the chair, long live.
Thank you, Chairperson. Goodbye, everyone.
Thank you very much. Bye, everyone. Thank you.